Assalamu alaikum. Hello everyone. This is Mehroze Aziz Niazi, Advocate High Court from Multan. I am here on the invitation of Muhammad Abbas Sayal, Advocate High Court, who is the founder of this instant channel. I am doing practice in Lahore High Court Multan bench since 2011. This is my background. I did my LLB honors from Bahauddin Zikri University, Multan, and fortunately, I am first gold medalist of my batch. Thereafter, I got partial scholarship for LLM from United Kingdom. I moved there in October 2011, but I was unable to complete that course due to the sudden demise of my father. I returned back to my country, Pakistan. I started my practice, and at present, I had appeared in almost 1500 of cases before the Honorable High Court. I also received the fitness certificate from Lahore High Court for the enrollment in the Supreme Court bar. Uh, Mr. Abbas told me that he is just going to start a new channel with the name and style of the legal debates. The aim and purpose of this channel is to provide latest information about law, basic law, the judgments of the superior courts, and point of view of our famous and renowned lawyers, as well as the point of view with respect to the former justices of the courts. So at present, I am here to discuss something about writ. Writ is basically the extraordinary constitutional jurisdiction of the High Court or the Superior Courts as Supreme Court of Pakistan. Article 199 of the Constitution basically define about the writ, its jurisdiction, its kinds. So I will going to start with the definition of writ. It's my humble point of view, it's my own interpretation, apart from the definition which is available in various law dictionaries or various related other books. I think a writ is a written command issued by the sovereign authority to its subordinate, and that subordinate may be a court, maybe any public functionary or a public department. This is a writ which is issued by the sovereign authority to its subordinate with a particular direction to do anything or to refrain from doing anything. This is all about jurisdiction. The next step for this purpose, I would like to discuss that when the writ is maintainable. It is only maintainable where there is no other alternate, adequate, and efficacious remedy available. In that eventuality, we can file a petition under Article 199 of the Constitution of Pakistan. So it will only come into the force when we have no other alternate or adequate or efficacious or speedy remedy available with us. For example, I would like to quote an example that Mr. Ahmed is going to apply for the post of lecturer. He appeared in the written examination, he was shortlisted, and then he was called to appear before the interview tribunal. He appeared and cleared the interview, but afterwards it came into his knowledge that certain term and condition of the appointment is changed, and now Mr. Ahmed will not be appointed under the new terms and condition. So Mr. Ahmed has no other remedy to avail. First, he has to challenge that terms and condition before the relevant department tribunal, and if they finally refuse to Mr. Ahmed, then he will have to file a writ petition having no other remedy. It is just an example. So now I would like to discuss about various writ petitions which are available under Article 199 of the Constitution. And I'm going to divide these 5 writ petitions in 2 categories. First of all, I would like to discuss about mandamus, prohibition, and certiorari. There is a condition to file these writ petitions. If a person is directly aggrieved from any order, from any action, or inaction on the part of any authority or department, then that person is competent to file a writ of mandamus, prohibition, or certiorari. For example, if the station house officer is unjustifiably harassing me, then I am the only person who can file the prohibition petition before the Honorable High Court. There is no other person who can file prohibition petition on my behalf. So this is the very important aspect, that in these writ petitions, the person should be directly aggrieved, then he will be competent to file a writ petition. So the next category is habeas corpus and certiorari. To file these two writ petitions, it is not necessary that a person should be direct aggrieved from any action, inaction, or any order. For example, if Mr. Ahmed is illegally detained by the station house officer, then any person from the world or from our country can file a petition to recover from the illegal custody of the station house officer. It is not necessary that a person should be aggrieved. So coming back to first three petitions, namely prohibition, mandamus, and certiorari, I'm going to discuss about prohibition. Prohibition is a kind of writ petition in which only an aggrieved person can file to receive a direction from the Honorable High Court against a person refraining him or her to doing anything which he is not entitled to do. For example, if A and B contracted love marriage and station house officer is harassing them on the behest of the family of that girl, then that girl is competent to file a petition before the Honorable High Court seeking a direction from the court to refrain the concerned SHO to cause any sort of unjustified harassment to that girl or to her husband. Now I'm going to discuss about mandamus. It is, against some person who is not doing anything which he is under heavy duty of law to do. For example, if my application of change of investigation is pending before the CPO Multan and he is not deciding that application within the timeline which is provided in Police Order 2002, then I, be an aggrieved person, can file a writ petition before the court seeking a direction to CPO Multan so that he will decide that application, because he is under duty to decide that application in the light of Police Order 2002. The third sort of writ petition is certiorari, that is against illegal, unlawful, or any irregular order of any court or tribunal. For example, a petition has been filed before Justice of Peace against me, and the Justice of Peace issued a direction to SHO to register a criminal case against me. Then I, being an aggrieved person, file a petition before the Honorable High Court against that order. So this is the writ of certiorari. Now I'm going to discuss about habeas corpus and certiorari. As I already told that there is a condition for first three writ petition, that the person should be an aggrieved person to file those writ petitions, including mandamus, prohibition, and certiorari. But for these two writ petitions, including habeas corpus and quo warranto, for these two writ petitions, it is not necessary that a petitioner should be a writ of habeas corpus. This is the writ petition any person can file before the Honorable High Court to recover a person who is unlawfully, illegally, and unconstitutionally detained by any person. So for recovery of any detainee, we can file a writ of habeas corpus. I'm going to discuss the last kind of writ petition, which is quo warranto. For that, it is not necessary that a person should be aggrieved. Any person can file a writ petition of quo warranto. Quo warranto is basically a writ in which the petitioner is seeking a direction from the court to ask anyone as to under what law and capacity you are using that office, or you are using the powers of any office. It is a writ of quo warranto. So I think in the first segment of writ petition, this is little information, and the viewers may understand what the writ is, what are the kinds of writs, and who person is eligible to file a writ petition. Thank you very much.